All rise.
Thank you. Please be seated. All right, we're back on the record. State of Nebraska versus Anthony Garcia, CR 13-2322. Prior to going off the record, I think it's apparent that Judge Randall was experiencing some difficulty. Had a procedure this week that resulted in some back pain as a side effect, and I think he carried it out as far as he could today. I know Judge Randall, he would have continued if he could. He couldn't. At any rate, Judge Bowie and I have conferred and decided that if there is no objection going forward, then we will do so. Is there any objection from the state?
No, Your Honor.
Any objection from the defendant?
Your Honor, we have to object for the record. The Nebraska statutes don't address this particular situation. Obviously, it's highly unusual for a defendant to be sentenced in the absence of one of the sentencers, the judge. In this case, the presiding judge. It's obviously highly unusual, and it seems like the better course would be to complete this hearing at another time when Judge Randall could be present.
Thank you, Mr. Pickens, and I would agree it is highly unusual. I will tell you for the record that this order was signed by all three judges, including Judge Randall, prior to going on the record. All we're doing, and I think Judge Randall acknowledged the fact, as we're reading it into the record, having all three signatures attached to it, this order can be filed, be made effective yet today. So I'm going to overrule your objection. As I recall, we were discussing psychiatric and psychological treatment. So I'm going to proceed with the order. There's evidence the defendant sought psychiatric and psychological treatment and at times was prescribed medication as part of that treatment. In the panel's view, the defendant's psychiatric or psychological history does not rise to the level of a mitigating circumstance to the actions taken by the defendant in the commission of the murders of Thomas Hunter, Shirley Sherman, Mary Brumbach, Roger Brumbach. These murders were separated by 5 years, during which time the defendant worked full-time as a physician, supported himself, purchased a home, and demonstrated he was capable of being a law-abiding citizen. Section D, Proportionality. The panel is required to determine the propriety of a death sentence by conducting a proportionality review. Such sentence determination shall consider whether the sentence of death is excessive or disproportionate to the penalty imposed in similar cases, considering both the crime and the defendant. Nebraska Revised Statute 292522 subsection 3. See also Vela, State v. Mata, State v. Dunster. This review requires the panel to compare the aggravating and mitigating circumstances in the case before it with those present in other cases in which a death penalty was imposed. The purpose of this review is to ensure that the sentences imposed in this case are no greater than those imposed in other cases with the same or similar circumstances. The Supreme Court has stated a proportionality review does not require that a court color match cases precisely. It would be virtually impossible to find murder cases which are the same in all respects. Instead, the question is simply whether the cases being compared are sufficiently similar, considering both the crime and the defendant, to provide the court with a useful frame of reference for evaluating the sentence in this case. The panel has undertaken a review of the Nebraska cases in which a death penalty was imposed as part of this proportionality review. The panel has mapped and considered all cases contained in Exhibit Number 1, which will be attached to this order. It also considered the opinion of the sentencing panel in State v. Jenkins, District Court of Douglas County, case number CR 132768, CR 132769. These cases are currently on appeal to the Nebraska Supreme Court. The panel first considered the defendant's murder of Thomas Hunter, Shirley Sherman, and subsequently Roger Brumback and Mary Brumback in relation to the murders and other cases in which the death penalty was imposed. There exists no precedent in Nebraska law for the fact that the defendant traveled from his home in Indiana to Omaha, Nebraska to commit 4 murders on 2 separate occasions separated by a period of 5 years. Those facts suggest lengthy premeditation and an exceptionally depraved mentality. The defendant had 5 years to reflect on the gruesomeness of the first 2 murders before he returned to Omaha to commit 2 more murders that were as equally gruesome. His actions indicate he had no remorse after the first 2 murders. In fact, the trial evidence suggests he bragged about them in an attempt to gain favor with the female he wished to engage in a romantic relationship. The defendant continues to evidence no remorse, and the panel finds nothing to suggest that he ever will. After a complete review of the cases referenced above, the panel unanimously concludes that the murders of Thomas Hunter, Shirley Sherman, Mary Brumback, and Roger Brumback, when compared directly to the murders in which the sentence of death has been imposed, a sentence of death in this case would not be excessive or disproportionate. The panel has considered the relative proportionality of the prior conduct of the defendants who were sentenced to death. The defendant now stands convicted of 4 murders. There is no doubt that all 4 murders were premeditated, yet there are any number of cases in which a defendant was sentenced to death in Nebraska where the prior conduct did not rise to the level of disregard this defendant has for the value of the life of another human being. Other cases in Nebraska involving more than 1 murder have been closely scrutinized. See State v. Jones, State v. Jubert, State v. Ryan, State v. Lauder, State v. Williams. All these defendants were sentenced to death. For example, in State v. Hessler, Hessler was sentenced to death based in part upon findings that he had substantial history of serious assaultive or terrorizing criminal activity. The murder was committed in an effort to conceal the commission of a crime, and the murder was especially heinous, atrocious, cruel, or manifested exceptional depravity. Hessler had not been convicted of a prior murder. Jubert involved the defendant convicted of 2 counts of first-degree murder for the killing of 2 young boys. Jubert was sentenced to death in each case based partly on the finding that he had a substantial history of serious assaultive or terrorizing criminal activity. Jubert had not been convicted of a prior murder. The panel also notes that the death penalty was imposed in State v. Gales and Williams. Gales was sentenced to death based on findings that he had previously been convicted of a crime of violence, as well as the particulars of the instant crime, but not a prior murder. Williams had previously been convicted of a crime of violence, but not a murder. In summary, the panel has conducted a thorough review of the death penalty cases and considered whether the sentence of death is excessive or disproportionate to the penalty imposed in similar cases, considering both the crime and the defendant. The panel has reviewed the nature of the murder in each case, as well as the prior criminal conduct of the defendant, which supports the ultimate finding that the death sentence was appropriate in each of those cases. The panel concludes the sentence of death for the defendant in each of those murders is neither excessive nor proportionate to the penalty imposed in similar cases. Conclusions. The jury found beyond a reasonable doubt all of the aggravating factors alleged. The panel finds that giving the defendant the benefit of all inferences, there is one statutory mitigating factor, and that being the defendant has no significant history of prior criminal activity. Further, the panel does not find the existence of any non-statutory mitigating factors, and the panel finds that a sentence of death is not excessive or disproportionate to the penalty imposed in similar cases. All findings are made unanimously and beyond a reasonable doubt. Sentence. It is therefore ordered, as to count 1, murder in the first degree, a Class 1 felony of Thomas Hunter, on or about the 13th day of March 2008, the 3-judge panel orders that a sentence of death is imposed upon the defendant, Anthony Garcia. As to count 2, use of a deadly weapon, not a gun, to commit a felony, a Class 3 felony, the presiding judge orders that defendant Anthony Garcia is sentenced to not less than 19 years, but more than 20 years imprisonment. This sentence shall be served consecutively to the sentence served in count 1 as provided by law. As to count 3, murder in the first degree, Class 1 felony of Shirley Sherman, on or about the 13th day of March 2008. The three-judge panel orders that a sentence of death is imposed upon the defendant of Anthony Garcia. As to count 4, use of a deadly weapon, not a gun, to commit a felony, a Class 3 felony. Presiding judge orders that defendant Anthony Garcia is sentenced to not less than 19 years nor more than 20 years imprisonment. This sentence shall be served consecutive to the sentence in count 1, 2, and 3 as provided by law. As to count 5, murder in the first degree, a Class 1 felony of Mary Brumbach, on or about the 12th day of May 2013. The three-judge panel orders that a sentence of death is imposed upon the defendant, Anthony Garcia. As to count 6, use of a deadly weapon, not a firearm, to commit a felony, Class 2 felony. Presiding judge orders that defendant Anthony Garcia is sentenced to not less than 49 years, nor more than 50 years imprisonment. This sentence shall be served consecutive to the sentences in counts 1, 2, 3, 4, and 5. And as to count 7, murder in the first degree, a Class 1 felony, Roger Brumbach, on or about the 12th day of May 2013. The three-judge panel orders that a sentence of death is imposed upon the defendant, Anthony Garcia. As to count 8, use of a deadly weapon, a firearm, to commit a felony, Class 1C felony. The presiding judge orders that defendant Anthony Garcia is sentenced to not less than 49 years, nor more than 50 years imprisonment. This sentence shall be served consecutive to the sentences in counts 1, 2, 3, 4, 5, 6, and 7. And as to count 9, attempted burglary, a Class 4 felony, presiding judge orders that defendant Anthony Garcia is sentenced to not less than 20 months, nor more than 5 years. This sentence shall be served consecutive to the sentences imposed on counts 1, 2, 3, 4, 5, 6, 7, and 8. It's further ordered the clerk of the district court shall deliver a copy of this judgment, a sentence, to the warden of the Nebraska Penal and Correctional Complex or other proper and qualified officer charged with the execution of this sentence. Such copy shall serve as the order and direction to execute this sentence by inflicting the punishment of death by whatever method may be enacted by the Nebraska legislature. It's further ordered a signed or certified copy of this judgment sentence shall be delivered to the Sheriff of Douglas County, Nebraska, who shall promptly deliver defendant Anthony Garcia to the warden of the Nebraska Penal and Correctional Complex. Further ordered that in accordance with the Nebraska statute, the court reporter shall prepare a bill of exceptions as in other cases, and the clerk shall prepare and file with the clerk of the Nebraska Supreme Court a transcript of the record of the proceedings and any other records required by the Supreme Court for which no charge shall be made, in order that the required automatic review of this order of sentence may be made by the Supreme Court as provided by law. Stated this 14th day of September 2018. This order is signed by the presiding judge, Gary Randall, Russell Bowie, and myself, Rick Schraner. Anything further, counsel?
No, Your Honor.
Mr. Garcia, you are remanded to the custody of the Douglas County Sheriff for execution of this sentence. We're adjourned. Thank you.